Thank you, Your Honors, and good morning. May it please the Court, I'm Ross Intellisano for Appellant Paul Feinstein. I'd like to reserve 3 minutes for rebuttal. The case law is clear that removal jurisdiction is based solely on statute. The defendant bears the burden of proving removal jurisdiction. The district court in this case ruled that the FDIC's removal of this case under the FEREA removal provision and the general removal statute does not appear to be proper. Now, 2.5 years after the FDIC improperly removed this matter from FINRA, it has advised this court that they are not challenging the district court's
So would you agree that the FDIC had a right to have the decision made with regard to this dispute in a different forum? You just think they went about it the wrong way?
No,
they should have repudiated the arbitration provision, and that would have ended the arbitration, and then the claim, if at all, would have had to be pursued through the FIREA process, or what?
No, I believe once we put in our claim, we had the right, as long as there's an arbitration clause, that the FDIC could be sued in arbitration, and courts have moved the FDIC into arbitration, including this court, in the Oregon Bureau of Labor case. So no, I do believe that irrespective of whether or not they did it improperly, they would still be in arbitration.
But isn't the whole point of this statutory construct, it's almost like a bankruptcy for a bank. You want all the claims to be gathered in one spot and adjudicated and assets distributed. And
that's true unless the FDIC is assuming agreements with parties that have underlying arbitration agreements. So in this situation, the FDIC, in this situation, the FDIC came in, it became the receiver for First Republic Bank, and in that process of doing that, the FDIC assumed all the liabilities of FRIM and Frisk. Okay,
it assumed all the contracts, and then it can disaffirm any contract it wants to, right?
Correct, but there are underlying agreements that it did not disaffirm in this situation.
But that's what I'm saying. So you think they could have done it, they just did it the wrong way. They
Correct.
should have disaffirmed more contracts than they did.
Including the FRIM, the transition bonus agreement between First Republic Investment Management. But the one thing they couldn't repudiate is the FINRA rules, because the reason why we're in FINRA is because First Republic Securities Corporation is a registered broker-dealer. Any disputes between a registered broker-dealer and a registered rep have to be heard at FINRA. When they took over those liabilities, they sit in the shoes of First Republic Securities Corporation and therefore have mandatory arbitration. So even if they did it properly, the FDICR should still be in the FINRA arbitration. And with respect to First Republic Investment Management and Frisk, it's even more clear and a completely different analysis. In that situation, in May 1st, 2023, the FDIC appointed as receiver the First Republic. Then there was a purchase and an assumption agreement on the same day. And in that purchase and assumption agreement, the FDIC moved all the assets to JP Morgan. So now JP Morgan owns the claims against our client, Mr. Feinstein. In May 2023, 2 weeks after the receiver was appointed, the FDIC substituted in our arbitration for only First Republic Bank, not for FRIM and Frisk, because FRIM and Frisk are still owned by JP Morgan, right?
So if your client wins, whatever the forum is, whose assets are going to satisfy that judgment?
If he wins in his claims against the FDIC, it would be the FDIC. But that has nothing to do with FRIM and Frisk's claims against him. And there are $16 million worth of claims in FINRA related to that.
Does he have any claims against them, though, or are all his claims that would now be satisfied by assets that are controlled by the FDIC?
Yes, the answer to that is yes, Your Honor. So what's very important to us is what's happened now is, first of all, now we have the FDIC admitting that it's no proper removal. FRIM and Frisk are now riding the coattails of the FDIC and saying they should be also in federal court. However, we have these underlying arbitration agreements that are still alive with FRIM and Frisk. And after we filed the arbitration in February of 2020, FINRA specifically sent a note and letter to FRIM and Frisk saying all disputes with them had to be arbitrated. And that was before the submission agreement was even signed by FRIM, Frisk, or the FDIC. So there is jurisdiction that's still alive. Now, irrespective of all the machinations by the FDIC to try to be in federal court, it has nothing to do with Frim and Frisk. There are still live arbitration agreements, including this transition bonus agreement between Frim and Mr. Feinstein, and also the FINRA rules, because First Republic Securities Corp is a FINRA broker-dealer, and they can't vitiate that. So when the FDIC tried to repudiate the submission agreement, they sent that repudiation only on behalf of the FDIC and First Republic Bank. They did not send it on behalf of Frim and Frisk because they didn't own Frim and Frisk. JP Morgan did. So that specific repudiation says it's not a repudiation on behalf of other parties. Those other parties are Frim and Frisk with these underlying agreements. So even if the court here finds that the repudiation by the FTC was proper, which we don't think it was, it has absolutely no effect on Frim and Frisk. They are still bound by the active agreements. And the Supreme Court in the Byrd case found that the FAA leaves no room for discretion, and the district court shall direct the parties to proceed in arbitration if there are active arbitration agreements. And with Frim and Frisk, there are. Now, what Frim and Frisk are arguing, strike that. So Frim and Frisk know that that's the case because after a receiver was appointed, Frim and Frisk filed arbitrations against 16 other former employees and registered reps, similar to Mr. Feinstein, at FINRA, proving that they know that they still have mandatory arbitration clauses against these employees. Now what they're trying to argue is that there's an intertwining effect between their claims against us and our claims against the FDIC. But the Supreme Court in Byrd specifically rejected that argument and requires that the district court...
But this is all about whether Frim and Frisk should be in arbitration.
Yes.
Can we go back to whether FDIC
Sure.
should be in arbitration? Because
Happy to do that.
I mean, I think under 12 U.S.C. 1821 D6A2 or whatever says you can continue the action if it's a pre-petition action.
Correct.
But only in two fora, and missing from the list is an arbitration panel.
It is certainly a novel concept and a novel argument and a novel issue here. So here's what happened there. The judge, the district court, found that 1821 is not a mandatory venue provision for federal court. And he was following the Holmes decision in the Sixth Circuit.
Sure seems like by its language it is, though.
Yeah, but that's not, I don't think, there hasn't been a lot of cases where there is already an arbitration.
Yeah, but do you have a textual argument that it isn't a venue selection provision?
Well, I think if it was intended to be a venue provision, it would specifically say that, and it doesn't. And the statute says to continue an action. It doesn't say to continue a court claim or continue a federal court case. It says continue an action.
But
so
it
contemplates
says where that can be continued, right?
Excuse me?
It says where that can be continued.
In a different section it does, but not in a section.
No, in D6A2 it says can be continued in one of these designated fora, and it lists, I think, the principal place of, the district that includes the principal place of business and the district for the District of Columbia. Right?
Correct. That is true, Your Honor. That's what it says. But in the only other case that has ever occurred where that either side has found where there was a pending arbitration before the removal, the Mapfre case in Puerto Rico, the judge decided that continuation was permissible in arbitration. And here in the lower court, that's what the judge decided.
But what did they say about the language of the statute?
They said it wasn't clear enough to force all petitioners to have all their disputes heard in federal court. And there have been lots of cases around the country in which the FDIC has been forced to litigate in an arbitration forum and not in federal court. It just doesn't happen very often because the FDIC doesn't very often remove arbitrations. And here, they didn't even have the ability to do that. So here, and what happened in our case is we filed a continuation request at FINRA, which is very similar to what happened in the Mapfre court, and found that was enough, and the judge found that was enough as well. And we believe there's no independent basis for either of the defendants to be here in federal court. But specifically, First Republic Investment Management and Frisk. And I focus on that because, there's been some argument about whether or not the arbitrators would have the ability to make decisions based on FIRREA as a statute. And here, we've already had 10 days of arbitration at FINRA. We have a very sophisticated arbitration panel. They have been asking every 3 months for an update. There is no doubt that this arbitration panel has the ability to see whether or not any of their defenses or our defenses FIRREA plays a role in.
Well, it can't be the rule, though, that in deciding whether to send it back to arbitration, you look at the composition of the panel and see whether you're going to have sufficient belief that they'll get it right, can it?
No, I don't. I think you're right. But I think what we've heard from Frim and Frisk is that they believe the only place where anyone can rule on FIRREA or any defenses related to FIRREA would be in federal court. And what I'm saying is that there are very sophisticated arbitrators who can, of course, rule on statutes.
But that rule suggests it turns on the sophistication of the arbitrators, and if we had unsophisticated arbitrators here, it may be a different argument, and I don't think you want to make that argument, do you?
I am not solely relying upon that.
Okay.
If, at the end of the day, the court decides to bifurcate this proceeding and forces us to go forward against the FDIC in federal court, and then we are in arbitration with Frim and Frisk. If Frim and Frisk believes, and we knock out the case, and they get a 0, they have the ability to move to vacate the award in federal court, and that's the proper standard. That's the proper procedure for them. The FDIC would have the same thing. And all we're asking you to do is, because there's no jurisdiction to actually be here, send everyone back to FINRA. Then the FDIC and First Republic Investment Management and Frisk can make a decision. They can either decide they want to stay at FINRA. They could also ask FINRA to decide whether or not they have jurisdiction or not, or they can move in court to stay the arbitration. With respect to Frim and Frisk, I think there's no doubt that we're going to stay there. With respect to the FDIC, they might choose to stay there too.
Move in court. Which court? One of those two designated fora?
Yes, yeah, it'd be in court.
Northern District of California, I guess?
Excuse me, yeah.
Northern District?
Or the Central District. I mean, Northern District would probably be, yes. The Northern, yes.
I mean, if we want to go with the 1821 D6A, it would have to be Northern District of
Yes.
California,
Well,
right?
they moved here in the Central District because the arbitration was venued in Los Angeles. Now, one of the other issues involved in the case is the timeliness of our motion to remand. And this is a clear and erroneous standard for that. We believe, abuse of discretion. We believe that it's nowhere near close to an abuse of discretion. The judge has the ability under Rule 6 of the Federal Rules of Civil Procedure to control his docket, and that's exactly what he did in this case. There's been lots of argument about gaps between the stays. I think the judge in his order on November 27th was very clear that the stays continue until December 13th, 2023. And he found in this case that there was a minimum amount of good cause and excusable neglect for us to file our motion to remand. And it's our belief that that's nowhere near the abuse of discretion standard. If there's not any more questions, I'm happy to.
Time for rebuttal.
Thank you so much.
So you're splitting time, so we've given you 10 minutes. So
Yes,
we'll
Your Honor.
stick to that, and then we'll hear 5 minutes from your co-counsel.
Good morning, Your Honors. May it please the Court, John Garisco, representing the FDIC as receiver for First Republic Bank. The world changes when a bank fails. That's what FIRREA does. One of the main things FIRREA does when a bank fails is it establishes a comprehensive claims process by which any claimant who has a claim against the receivership puts the claim through the claims process. This court has made clear in Benson, in Rundgren, and in Shaw that this is a jurisdictional requirement to exhaust the claims process. Mr. Feinstein filed an administrative claim against the receivership. but he didn't follow through. What the statute requires, as this court has alluded to, it begins with filing a claim. If the claim is disallowed, then we go to 1821 D6 for what happens next. And what happens next is there are three choices. The first choice is not at issue here, which is the claimant may request administrative review of the claim. The second choice is that the claimant may continue an action commenced before the appointment of the receiver. And the third option is to file a new lawsuit. As we argued in our brief, we believe, contrary to the map-free court that counsel alluded to out of the District of Puerto Rico, that the text of 1821 D6 does not allow a finding that an arbitration commenced before the appointment of the receiver is an action that can be continued.
So, independent of like who should be making the decision, what's the statute that allows a removal from arbitration to federal court? Like, what statute would you point to that says this arbitration can be removed to federal court? I get the argument that you could maybe disaffirm the contract and shut down the arbitration by saying we no longer agree to arbitration, figure it out, do what you want, file an administrative claim. I'm a little confused about the removal language.
Certainly, Your Honor. The FDIC special removal statute is 12 U.S.C. 1819 B2B. We argued below that the removal of this arbitration to federal court was proper under 1819 B2B. We relied on, most importantly, the precedent from this court and other courts of appeals, recognizing that Congress, in creating this special removal power for the FDIC, intended the FDIC's power to remove to be much broader than the general removal statute, 28 U.S.C. 1441, and that the FDIC should have every opportunity to have a federal forum. And below, we argued that that language supported removal of this arbitration proceeding. As the court's aware, on appeal, we have elected not to challenge the district court's finding that Section 1819 B2B did not authorize the removal of Mr. Feinstein's arbitration from FINRA. Again, though, as the district court, that tracks with what the district court found, which is that this removal was not authorized by statute. The district court ultimately held, though, that the FDIC had properly repudiated the one agreement in this case that required First Republic Bank to arbitrate at FINRA, which the parties call the submission agreement.
And so it's only FRIM and FRISC, to use the acronyms I guess we're throwing around, that are subject to FINRA. The FINRA obligation to arbitrate doesn't extend to First Republic?
First Republic voluntarily submitted to FINRA jurisdiction by signing the submission agreement. The FDIC then authorized its statutory repudiation power under Section 1821E to say we are not.
So the arbitral jurisdiction arose as a result of a contractual choice that First Republic made, not as a result of a FINRA regulation.
Correct. First Republic Bank was not a broker. It had no obligation to be in FINRA. It voluntarily, because the allegations here are essentially allegations against the failed bank, First Republic Bank entered into the arbitration. As your honors are aware, the note that's one of the issues in the arbitration that is now in court, that note was given to First Republic Bank. So First Republic Bank came in as a counterclaimant or third-party claimant, whatever nomenclature you want to use, to deal with the note issue. And so it voluntarily submitted. But that contractual voluntary submission is something the FDIC could repudiate under 1821E, and it did repudiate, as we explained in our brief.
So can I ask a question? So we're dealing with an appeal from the Central District, right?
Yes.
But the case has been transferred to the Northern District.
That is what the district judge, his last order transferred the case to the Northern District of California.
Just help me understand why it was ever in the Central District. Why didn't, when you removed it, you could have designated where, right? And you designated Central District rather than Northern District. Why did you do that? And does it matter?
It's not in the record. I don't know, and I don't think it matters because the case
You
was.
would agree now that the case should end up in the Northern District.
We do, because Mr. Feinstein was given the option of the two courts designated under 1821d6, either the Northern District or the DC District Court. He chose the Northern District of California. So that is where this case, as the district court, anticipated when it transferred the case, that's where this case should be decided.
Am I clear that the counterclaims, you wouldn't be here to address the counterclaims. That's other counsel. Is that right?
Yes, Your Honor,
Okay.
counsel for the subsidiaries.
Okay.
And again, if
But you think it shouldn't proceed in the Northern District either because they didn't file timely within the 60 days or not?
well, no, that's correct. The case should be in the Northern District.
And then it should be
But-
dismissed.
Right. The
But
case.
that's not before us.
Right, the case, as we argued in our brief, we believe that 1821d6 does not allow these, Mr. Feinstein's claims against the FDIC to continue. That leaves
So that
the
means-
counterclaims.
Right, but you, if this goes to the Northern District as opposed to back to the arbitration panel, then you're going to go in and file a motion to dismiss.
Well, yes, we will. We will file a motion to dismiss. Again,
I don't think that's a secret. If you think that that's a litigation tactic, you don't need to tell me.
No, certainly, Your Honor. Again, we raised it in this here because it's a matter of subject matter jurisdiction. So we raised this issue that even though we understand why the district court did what it did to give Mr. Feinstein an opportunity to pursue his claims, we don't believe that the text of Section 1821d6 allows that. And that would mean that what would remain of the case would be the subsidiaries' counterclaims against Mr. Feinstein, which would go to the Northern District of California, we believe.
Why do they need to go to the Northern District? Why can't they stay in a Central District?
That's a good question, Your Honor. I suppose that to the extent
Did
that
the district court ordered the entire case up there, though, including
the district court did order the entire case up to the Northern District of California. And again, counsel referred to this issue of intertwining because certain of the issues involved in the counterclaims may implicate FIREA. It may be a situation where ultimately it would be proper to have those decided in one of the courts designated under 1821d6.
Right. So
And
as I understand it, if they somehow, and I may not be saying this entirely properly, but if they somehow would affect the assets that are now under FDIC receivership, then they basically would then come under coverage of the statute and so that would make sense that those claims, if that was the case, would belong to the Northern District, and then maybe you'd seek to dismiss them or something. But if they don't, and it just ends up that FDIC is not implicated at all for a counterclaim, which I don't know if that's true or not. I don't know if we know whether that's true or not. For those claims, I'm just curious as to why they needed to be in the Northern District, what the hook is for transferring those claims. I suppose other than you've said that they might be intertwined, but it seems like by definition they wouldn't be intertwined. If they were intertwined, they would be the type of thing that might affect the the assets under FDIC receivership. So I'm talking about a world in which they're not.
Certainly, Your Honor. And again, the case was transferred as a whole. Really, if the FDIC is by definition out and none of the issues relating to the counterclaim were to implicate the FDIC, then 1821d6 might no longer be a factor. But I think counsel for the subsidiaries might have a better idea of, or might be able to opine as to whether the Central District would be sufficient if this case was limited only to their claims against Mr. Feinstein.
Okay, maybe we'll hear from them then.
We ask that the court affirm the district court.
Good morning, Your Honors. May it please the court, my name is Dipanita Amar. I represent the entities that we're colloquially calling FRIM and Frisk. I'd like to start by actually answering a couple of the questions from Your Honors. To start with Judge Nelson's question regarding why was the case removed initially to the Central District. I believe the answer is the FINRA arbitration was pending in Los Angeles, and at the time, Mr. Feinstein had not yet pursued his administrative remedies by filing with the FDIC his request for claims. So if you look at the statute, 1821D, that's really what happens after an individual or an entity has pursued claims through the administrative process and thereafter
Northern
been
District
disallowed.
hadn't really ripened, if you will, until.
Exactly, Your Honor. That's exactly what happened at the time. After removal, Mr. Feinstein, on his own, voluntarily pursued the administrative process. When he did so not only with respect to his claims against FRIM and Frisk, but also he submitted the entire kit and caboodle, so to speak. He submitted the entire case, including FRIM, Frisk's, and First Republic Bank's counterclaims against him. So the entire thing was submitted through the administrative process, which in my mind is a very clear concession that Mr. Feinstein has made that the whole thing is effectively a claim for assets and liabilities now that belong to the FDIC. And once
Did the FDIC even have jurisdiction over the FRIM and Frisk parts, though?
the FDIC
The
First,
administrative process, I mean.
yes, absolutely. Because what Mr. Feinstein was seeking was a declaration, among other things, that the promissory note that he owed First Republic Bank, he had signed a $7.1 million promissory note, and he was seeking a declaration that he be relieved of the obligation
Sure,
to pay
it had
that.
jurisdiction over that. I'm talking about the parts that were just the FRIM and Frisk parts.
Yeah, so the parts that were the FRIM and Frisk parts are also parts that where he is alleging acts and omissions of employees of the bank, of First Republic Bank, which has now been put under receivership and belonged to the FDIC. So
you're arguing, but I mean, we need to even address that, can't we? Can we get the lower court to address that and not have to do the hard work? I mean, Judge Cole has to do this all the time in his home circuit. So do we really need to address that, or can the Northern District address whether or not the FDIC is implicated by some of these claims, which ones they might be implicated by? If they are implicated by that, then it seems like those would be treated differently than if it just turns out that the FDIC is not implicated. I understand your point, I think, is, well, by submitting to by bringing all these claims in the administrative proceeding, and he was impliedly at least acknowledging that was the case, but can't we let the district court decide whether that's true or not?
Actually, Your Honor, I think he was explicitly acknowledging. If you look at the cover letter of his submission, he was explicitly acknowledging that the counterclaims and his claims were all part of the same dispute. And indeed they were. They were asking for relief from acts and omissions of the bank, which by its very terms, Ferreira says, belong to the FDIC.
But I'm trying to figure out, because it doesn't even seem that was the reason why, unless I'm missing, that was the reason why we have this sort of interlocutory appeal. The reason for the interlocutory appeal is these tough questions about whether FDIC can remove something from arbitration and what they do and whether transfers like this thing you want, and I understand why you want it to be decided by us, but do we need to? That's the only question I'm asking. Do we need to?
I think the real answer is you don't necessarily need to, but I think it's almost implicit in the relief that we are seeking, because one of the pieces of the relief is that the entire action was removed. When you remove an action, you don't just remove some parties and not others. And so I think if the removal was appropriate, and we contend that it was, then the entire action is removed, and it needs to stay together as an entire action.
But if the removal was inappropriate, and but they blew the deadline to ask for it to be returned. So but haven't they also asked for arbitration of? They filed a removal request, motion for removal, but they also filed a request for arbitration. So isn't it possible that the lower court could take claims that it had determined do not implicate the FDIC? I don't even know if any of those claims exist, but if we don't decide that, but the lower court does, and then it decides those claims need to go back and be arbitrated before FINRA.
I don't think that the district court could decide that the claims as currently pled could be decided by FINRA. And the reason for that is the affirmative defenses in those very claims are the mirror image of our claims. So what Mr. Feinstein is contending in the affirmative defenses.
Right. So that's why you're probably right. You may be right. I don't. That they all have some sort of nexus or relationship to the assets under FDIC. In which case, but I'm just saying. Assume for a second with me, which it sounds like you disagree with it, but just assume that there was some claims that did not. That did not affect the assets under FDIC receivership, and so therefore did not fall under this whole regime of removing these claims. And why would those not be sent back for arbitration? I'm assuming they blew the removal deadline, but they do have an independent request for arbitration of those claims.
Right, and I guess the answer is if theoretically there were claims that were completely divorced of any liabilities that have been taken over by the FDIC, you could send the claims back to FINRA.
You could split it all up that way.
Theoretically. I just don't think it works in this case because Mr. Feinstein has conceded that they are
But back
all
to my
one
original
and the same.
question, we don't really need to decide any of that, right? We can let the district court do the hard work because we don't like to work hard.
Saying that, yeah.
And Dyke, quit getting us on the hook, Judge Van Dyke.
so we could send it back and have the district court, because they are I think as you've been getting at, they're interrelated. Whether or not the question of whether or not these are FDIC, any of these claims don't implicate the FDIC, and whether they should be arbitrated are kind of related. So, and also, it feels like we'd be speculating to decide some of these without deciding the whole package.
Yeah, I think you could punt that, Your Honor, to the Northern
Well, maybe
District.
just leave something for the district court to do. We don't.
She conceded. We're done.
Yeah, I think you could theoretically do that. I just think in this case that doesn't really work. Congress made this
No,
scheme
you
for a
said we
purpose.
could do it. So, that's all I heard.
Well, Your Honor, I think Congress made this scheme for a reason, and it.
No, it's a fair point.
And the reason is that the FDIC is in the driver's seat, and all these claims need to be where they want it to be. And if they've repudiated the agreement with FINRA, I think they belong all together. I'm getting cued that my time is up, so thank you.
Thank you.
But we took you over. Thank you.
And by we, he means me.
Okay, I might have to have you work a little bit hard talking about the causes of action, because there are 6 causes of action that Frim and Frisk have against Mr. Feinstein. 5 of those 6 have absolutely nothing to do with.
Well, so let's just take that as a given.
Okay.
Why wouldn't we let the district court figure that out?
As opposed
Because you don't want it to go there anyway. You want us to send everything back.
Correct.
But say we don't agree with that. Why couldn't we just say, you know what, this is complicated. Northern District of California, hey, I know you didn't want this case, but now it's yours. Figure out.
I think that is an option for you to do. I just think it's so clear that there is a pending arbitration clause between us and Frim and Frisk that the arbitrators can do that, and it's already set up, and they've already heard 10
Well,
days.
but if we send it back to the Northern District of California, I mean, I think it seems to me the question is how many of these claims, which ones, what are the implications? That
Right.
seems pretty detailed work that it seems to be, it would be good to have the district court decide in the first instance.
I agree with you that I think it is very detailed work. Although if you looked at the causes of action, there are literally ones about trade secrets, one's about a breach of fiduciary duty. They have absolutely nothing to do. There's the only.
But what, say we were to take it, now Judge Van Dyke's gotten into me. What if we were to take this
Yes.
on? What would we do? We would remand, we would like
Send some to arbitration.
Yeah,
send
I don't
some,
even understand what we do.
I think you would, after you look at them, and it's in the record at page 397, which is their counterclaim, I think you'll find that there are not any that really bring the FDIC into it. There are $16 million worth of claims against my client that have nothing to do with the FDIC.
But you're not in any worse position whether we have the district court do that work or whether we do that work.
I agree with you.
Okay.
And can I ask one related, which is, so I think your position is you want us to send everything back to
Yes.
FCRA, right, to arbitration. But assume for a second, I'm asking you to make an assumption that you may not agree, but assume for a second that we were to say, no, the stuff against for whether because we think you waived the 60 days or whether because you can't arbitrate claims, but the stuff against FINRA stays in the Northern District. If we were to, do you agree that the claims that you are saying under the assumption that you do agree with, which is that these claims don't affect FDIC at all, for those claims, could the lower court decide, could the Northern District decide to send those ones to arbitration, and could they split the baby, so to speak, here?
I believe the answer to that is yes. And our claims right now are against the FDIC.
And why wouldn't those claims stay? I think I asked, why wouldn't those claims just? It's not clear to me those claims, if they were just by themselves, should have been transferred to the Northern District, right? They would have jurisdiction in the central.
Our claim against the FDIC, well, I think the biggest reason why is because the repudiation was not a proper repudiation of the submission agreement, and it's a clearly erroneous state standard. But the FDIC was supposed to, and they're required to give us notification within a reasonable time period of any.
Right. We understand your arguments on that and stuff, but assuming that we thought it was a sufficient repudiation, why? If those claims were the only ones that existed, under your view that those claims don't implicate the FDIC, then it would have been okay to remove those claims to the Central District and not the Northern District?
I don't think it matters whether it's the Central District or the Northern District, but even if you find that the repudiation by the FDIC is proper as to the FDIC,
right.
there's still arbitration clauses in other agreements that they are bound by. So they would have had to vitiate.
So the removal aspect is not. You're moving to arbitrate because you also moved to arbitrate. You didn't just move to remand, but you also moved to arbitrate.
Yes.
Yeah, and so that I think my thought of that was that takes out the blowing the deadline
Correct.
aspect of
Correct.
the
Correct.
removal. What I know you have different
and the
views.
concept is we think everyone should be back at FINRA because there are live arbitration agreements, but at the worst, the FDIC would be in federal court and FIM and Frisk are in arbitration because there's nothing in their claims against us that warrant a federal court to decide. And there are live arbitration clauses.
So I think what Judge Van Dyke may have been asking, maybe not, I may be wrong about this, but assuming that's right, could the Northern District of California be the court that decides to send those other claims, the Frim and Frisk claims, back to arbitration, or should that have been decided by the Central District?
I believe, I don't know the answer to that question, Your Honor. That's a good question because it's never really been raised before. I don't know the answer to that question. I believe now that it's been transferred, then I presume it would be the Northern District. We would prefer to have you do the work, to be honest, but.
Everybody wants to work on the Ninth Circuit. No, look, thank you.
Thank
You're over, but we took you over as well.
Thank you, I
But look,
appreciate that.
thank you to all counsel for your arguments in this complicated case. It's very helpful, and the case is now submitted. And that concludes our arguments for this.
All rise. Hear ye. All persons having had business with the Honorable, the United States Court of Appeals for the Ninth Circuit shall now depart for this court for this session. Stands adjourned.